ask, and I remember I read your book and really enjoyed it. And so you were talking mostly in the lecture today about some of the material support laws under 18 USC 239. 2339B, if I got it right. So there was also in your book you talk about 2339A,
yes,
which is kind of material support not just for like terrorism-related charges, but also for like a couple dozen other felony charges.
yes.
And so you see, I was wondering about the ways in which. So you talk about them working together very well because if 2039B prosecutors kind of can't indict or on that or sentence, they kind of fall back on larger felony questions and for criminal law. Basically, I'm wondering, does this material support stuff come up in relation to other kind of mid-90s efforts by prosecutors to kind of begin clamping down on material support in other domains that involve kind of fiscal mismanagement in the 90s? I'm kind of looking forward to kind of like Enron. Like Enron happens right when 9/11 happens, and the extent to which these anxieties about Muslim terrorists during the mid-90s are part of a larger set of arguments being floated through courts about kind of private money raising and crime. I don't know if you would be able to kind of talk about the way that figures into, I guess, earlier RICO laws, but then how RICO laws are being changed.
Well, the thing that, I think the thing about it is that the material support law, specifically the 2339B, but the 2339A, this is applicable too, but specifically it's foreign terrorist organizations. So a lot of commentators made the point that there isn't a corresponding FTO list for domestic groups. And because in the situations you were referencing, Enron or large-scale corporate fraud or things like that, the laws are already on the books that deal with these things kind of in a clear and defined manner to a large degree. I think when we think fraud, financial fraud, we have a general idea of someone engaging in some dirty business to kind of take money for themselves when they shouldn't. Whereas when you bring up the concept of material support, at least for me, the general sense is there's some sort of tangible aid in the form of money or funds or maybe some equipment or something like that that frees up, like we were discussing, frees up money for violence. So there's a link, and even though I don't think it's a strong link or a proper paradigm or I think it's a paradigm that's been exaggerated, it's still one that conceptually you can kind of understand, and it's just kind of gone. It's run amok, but it was designed specifically to deal with this idea of the foreign threat. Because I think when you've looked at the issues of domestic terrorism, the most kind of recent discussions we've seen is why are there no domestic terrorism laws for dealing with school shootings, which are far more deadly, right? But that's a whole other societal problem that I think Congress and states are having a harder time reaching consensus on how to address. One more point here is, that you've seen repeatedly efforts to kind of deal with the threat posed by domestic terrorism, which, a lot of kind of neutral, to the extent we can use that term, but sort of outside third-party researchers have identified with right-wing terrorism, anti-abortion terrorism, things like that. They've faced severe political backlash. I think that one of the problems we see with the focus on foreign terrorist organizations, and I didn't talk about this during the talk, but if you look at the list, I think we're talking about 60 groups, 46 of which are Muslim or Arab, Muslim in either ideology or makeup, and including something like the last 20 groups that have been designated have been Islamist groups. So it's clear what the government is saying as to who the terrorist enemy is. And, those are not groups that you can find a lot of support for in the country at large. Whereas, there are Congress people who are willing to, take on the idea of domestic, sort of anti-abortion activists as being, as being fine, upstanding citizens who are entitled to their point of view, who shouldn't be stigmatized, right? And I think, in the context of a peaceful position, you can understand that, but it's when things sort of veer on the violent, more toward the violent, that political support can come in handy, and it doesn't exist in the foreign countries. Don't want to render everybody speechless.
I kind of I was just thinking about the how, for example, they have people who go to be like foreign fighters, like let's say, like in Syria, for example. But then on the other hand, you have like American citizens who go and fight in Israel. So I'm just curious, like, why isn't there like a distinction?
Well, there's two. Okay, so there's two things to bear in mind. One is there's actually a law. It's actually now. Please try to keep hold of your stomachs here. But there's an actual law called 18 USC 2339D, which bans or criminalizes the idea of going to fight with a foreign group, attend a foreign training camp, etc. So there is an actual setting. You very rarely see it charged because it's just so much easier to bring material support charges. So you've seen already, and we've seen this paradigm if you follow in the law, for example, there was in the mid-90s, around the time of the passage of the material support law, there was also a series of harsh immigration laws, one of which authorized a special immigration court to deal with secret evidence that would allow the government to use secret evidence against individuals it felt were terrorist non-citizens or aliens. That's what the government called them. I don't like that phrase. But it never used it because it didn't like the judicial review provisions that it demanded. It seemed a little more rigorous than the government wanted. So it used secret evidence against individuals, but it used it under an easier provision. Likewise, in the material support context, even though there's a foreign fighter specific statute, it ends up not being used very much because it's just so much easier to charge material support under 18 USC 2339B. Now, with the context of going to fight with an FTO versus a specific country, you gave the example of Israel. There, sovereign states have different classifications, and the government recognizes them. So when it says a group is an FTO, all links are tainted. So this is a bigger point I think you make about the fairness in limiting terrorism to non-state groups, but that's what that debate, certainly not in the government, it doesn't get recognized anymore. I think I talk about in the book, that there were a whole series of debates about the nature of a political struggle. There were some cases in the 80s and 90s of individuals who had been implicated with the provisional IRA in Northern Ireland. They were applying for asylum in this country, and the British government wanted them extradited to face charges in Northern Ireland, and they argued that there was a political exception to extradition, which exists in the law. And a lot of the Irish individuals had success, whereas individuals who had been requested, Israel sought to extradite, were not successful. So the question was raised, what's the difference? And there you get into the thorny issue of A, state versus non-state terrorism, and B, there are significant communities in this country that don't view certain groups, the IRA, as terrorist. Whereas at the time in the 80s and 90s, Palestinian-affiliated groups were viewed as exclusively terrorist. So it's not, I think it's an excellent point to raise in a kind of an academic discussion, but don't look for too many answers from the law. I don't think you're going to find fairness and stuff like that.
I was just thinking more like, because I heard about, I'm just an undergrad, so I don't really know a lot about law.
Sure.
I was just thinking about like, like you, as an American citizen, as an passport, you go fight for like a foreign military.
Well, the thing about it is that it's also, these are things that are prosecuted at the discretion. I mean, if you go on to study these things, the level of discretion that a prosecutor has is essentially absolute. So, to charge someone or not charge someone, that's up to the prosecutor. And that's not something that you or I can go and try and force them to change their mind. So, I think with a lot of these statutes, a prosecutor can make very, what's the word I'm looking for? It can be quite creative if they want to go after someone, or they can just sort of drop it. So I think that's another paradigm you're confronting.
So I have a question. I was wondering if we could talk a little bit about Tarek Mohammed's case.
Sure.
And specifically, I was hoping you might be able to speak to the relationship between incitement to violence rhetoric out of Brandenburg and Holder versus Humanitarian Law Project.
Okay.
So in going back and rereading the court transcripts from Mohammed's case, what's so absolutely terrifying is this idea that part of the materiality in his case, the material support, comes in this form of the idea that the actions that he and his associates failed to do could inspire others in some possible future to commit a terrorist act, right? And that his online activity in particular constituted these material forms of inspiration. And I was just wondering if we could talk about this relationship between Holder and Brandenburg and what's being challenged.
Sure. So, when you talk about Brandenburg as the standard for the dividing line between First Amendment protected speech and criminal activity, sort of the lawless incitement to violent action. I mean, it's clear that there's no Brandenburg issue in the Mohammed case. Like he was not inciting in that kind of, shouting fire in a crowded theater type of situation that we've kind of come to imagine. The interesting thing about that case was, he had translated these materials and put them on the web, and the government had put them on a website that the government had alleged was affiliated with Al-Qaeda. Now the problem was, if you look at Holder, what it says is material support in the form of speech can only be criminalized if it's done at the behest of or in coordination with an FTO. And they didn't even bother to show that link. They just showed what they did was they said, well, he made this trip to Yemen where he allegedly went looking to join a terrorist training camp. And he didn't. He didn't successfully join a camp. That was undisputed. But the fact that he went apparently was enough to allow the material support charges to survive not only conviction but also the appeal of that conviction. So it was an interesting opinion to study because many people were looking at the Court of Appeals to finally tackle, well, what does coordination in the material support context, as the Supreme Court laid out in the Holder case, what does it really mean? Let's get some definition here. And the First Circuit Court of Appeals in Boston basically just fudged the whole issue and said, well, there's a series of, there's a bunch of evidence here, and the jury had enough to convict him because he did go travel to Yemen. So it dodged the issue there. So we don't really know. I mean, we still have this standard of in coordination with or at the behest of or whatever it is. But we don't have more of an idea of what that actually means. So certainly from a kind of a, I hate to use this phrase, but you'll forgive me, but from a court watcher point of view, it was disappointing. Although telling, I think, because the judge who wrote the opinion opened up with, terrorism is the modern equivalent of the bubonic plague. I don't know, the phenomenon of judges making these kind of statements that are not necessarily, well, they don't cite any evidence. It's just kind of personal opinion. I mean, I'd love it if I could just give my opinion about things and have the force of the federal government on it. it's not always satisfying.
Is there some type of disparity, would you say, between national security prosecutors and legal civil rights groups that has allowed the number of legal victories in these cases to side on the issue of national security in many broader interpretations of legal precepts, especially in criminal language?
Sure. I mean, I think there are two issues. I mean, one is just sort of a general. I mean, I think if you follow American criminal procedure since the early mid-60s, from the late 60s, early 70s, when the rulings, the so-called Warren Court Revolution, where there were all these what were perceived as pro-criminal defendant, criminal procedure decisions, you've seen sort of steadily that erode over the last 4+ decades, where the Supreme Court has basically allowed the police to do more and more and more and more, and get a kind of constitutional approval for that in a general sense. So I think there's a general trend within law enforcement that sides with, or a general trend, within federal courts that sides with the Supreme Court, specifically that sides with prosecutors. Specifically in the national security context, I think there really was a mindset that took hold certainly in the first 5, 6, 7, 8 years after September 11th. The courts were exceedingly deferential because the concept of another attack taking place was something that judges were extremely reluctant to. You know, there were some exceptions to this rule, but judges, I think, in the main, were very kind of susceptible to the government's arguments that the defendant in front of them was a real threat. So I think that's as we've seen more and more that the government has created a lot of the plots and the busts. I think we've seen a fair degree, a little bit more skepticism from judges, a little bit more kind of scrutiny, but it's still kind of a slow, incremental process that is taking place. Because I think, judges in courts in general don't want to be seen as weak on security in a general sense. So when charges come within that context, it's really, you're going to have your work cut out for you convincing a federal judge that the government's theories are misguided, overstated. So it's a kind of a structural construct that's hard to get around.
Maybe one more. Do we have time for one more, or do we want to call it there?
I have a more optimistic question.
Sure.
I tend to wax very doom and gloom in this research. I think the case that you may have alluded to in your talk was the Robertson case in Florida.
That was one of them, yes.
Yeah, and that was one of those moments when I'm watching the news and there's this, something potentially very optimistic just happened in terms of the judge's sort of opinion about that case and the appeal process. And so I was just wondering if you could talk a little bit about that.
Well, that was a case where, the government had essentially taken an individual who had been ensnared in kind of a terrorism investigation, but ultimately was never charged with any terrorism-related crimes. And what the government tried to do was, after he'd been convicted on the non-terrorism crimes, have him sentenced under the sentencing enhancement, right? So his sentence went way high. And that had never been done before. They'd never successfully employed the special terrorism sentencing enhancement, U.S. Sentencing Code, Section 3A.1, to a non-terrorism-based criminal offense. So it was kind of a new thing. And the judge in that case, the federal district court judge, basically said, you're going too far. Because they wanted to make the argument that he was terrorist affiliated because of some books they had found in his possession, etc. So I think that the judge in that case took a very principled stand, an evidence-based stand, a very careful stand that would probably survive appeal, but I think if the government is, I'm not sure if it, I don't think they appeal, which is smart because they're sort of limiting the precedential value there.
Okay.
But I do think that, to be fair to the Supreme, especially the Supreme Court and its sentencing jurisprudence over the last 15, 16 years, that's the type of thing that the court has really kind of tried to crack down on federal prosecutors overusing, maximizing their advantage to push for higher criminal sentences. It's interesting to see what will happen if the terrorism enhancement ever gets subjected to higher level scrutiny and actually gets up to the Supreme Court. But in that case, I think it was a kind of a strong case for the judge to rule the way he did.
Thank you.
Sure, thank you.
Thank you so much.